I didn't put makeup on any to conceal any. That is utterly preposterous. So it just didn't happen.
A sitting judge in Michigan covered up felony child abuse committed by her own son. She applied makeup to a bruised child's face. Then she lied about it under oath. And when the truth came out, she fought to keep her seat on the bench. The case of Judge Tracy Green is not about one family's secrets. It is about what happens when the person entrusted to uphold the law becomes the one breaking it. The story begins in Detroit, in a home where Gary Sr. lived with his wife and 5 children. In 2015, a court awarded him custody of his 2 oldest sons. The boys rarely saw their mother. They saw their grandmother, Tracy Green, at least once a week. Tracy Green was a lawyer, a child welfare specialist, someone who knew exactly how the system worked. She would later become a judge. But in that home, something terrible was happening.
Good morning, Your Honor. Respondent has a son named. In 2015, a Wayne County Circuit Judge awarded custody of his 2 sons to Gary Sr. instead of to their mother. The boys lived with Gary Sr. from 2015 until June 24th of 2018 and had very minimal contact with their mother during that time. Meanwhile, they saw the respondent, who is their grandmother, at least once a week. Gary Sr. and his wife Katie and their children lived in a home in Detroit. On June 24th of 2018, a neighbor heard sustained screaming in Gary's home. She suspected and she called the police. The police came and did a quick investigation and left the scene. About 5 hours later, Protective Services went out to the home and flagged down the police, and both the police and Protective Services went into the home. Protective Services had had contact with the family prior to that date. Child Protective Services made the decision to remove the children from Gary Sr.'s home on that day. The respondent came to the home and offered to take custody of. The boys told a police officer and a CPS worker that they didn't want to go with respondent and provided their reason. As a result, Protective Services placed the boys with respondent's husband's cousin, who was not related to them. In 2019, following a trial in the juvenile court, a judge terminated Gary Sr.'s parental rights to all 5 of his children. Also in 2019, Gary Sr. was convicted in the criminal court of 2 counts of the second degree against respondents' 2 grandsons.
On June 24, 2018, a neighbor heard sustained screaming. She called the police. Officers came, did a quick investigation, and left. 5 hours later, Child Protective Services arrived. This time, they went inside. They had been in contact with the family before. What they found would end Gary Sr.'s custody forever. CPS removed the children that day. When they told the 2 older boys their grandmother had offered to take them in, the reaction was immediate and chilling.
Were you present when somebody told them that their grandmother offered to take custody of them?
Yes, I was sitting in the stairwell with both the boys at that time.
Who told them that their grandmother offered to take custody?
It was the last CPS worker that made the location.
All right, let's start with first. What was his reaction to that statement that his grandmother offered to take custody?
He literally froze. His body stopped moving and he stopped talking.
Did he do anything else besides that?
Just at that point, that's all he did.
Did he say anything to you about that?
At that point in time, no.
How did he react when he learned that his grandmother offered to take custody?
He got quiet and stopped speaking as well.
All right, so when you talked with the boys about the possibility of them going with their grandmother, how was acting?
He stated that he did not want to go with his grandmother because his grandmother knew that the dad and she never did anything about it. When I said I would, I let the boys know, like, oh, I'll see if there's someone else. I'll talk to the CPS worker. And at that time, they both kind of just took like a deep breath and just relaxed and started talking to me.
One boy froze. The other stopped speaking. Then one of them said, she knew about what Dad was doing to us and she never did anything about it. That sentence changed everything. It opened a window into years of abuse and a cover-up that reached into the heart of the legal system. The investigation revealed that Gary Sr. had been physically abusing his sons. He would hit them with objects, leave marks on their bodies. In 2019, his parental rights were terminated. He was convicted of 2 counts of second-degree child abuse. But the boys had also told investigators something else. Their grandmother, Tracy Green, knew about the abuse, and she had put makeup on their faces to hide the marks. That was the allegation that would consume Tracy Green's career. She was by then a judge in Michigan's Third Circuit Court. The Judicial Tenure Commission filed a complaint. They charged her with covering up evidence of abuse and making
and
false
two
statements.
grandsons. That is the backstory to what brings us to this hearing. Respondent is charged with 2 counts in the complaint. The first accuses her of covering up evidence that her son, and the second accuses her of making false statements about her knowledge that her son was a boy. Now, he will testify that on multiple occasions, the respondent put makeup on she knew had been inflicted on him by her son. He will testify that on one occasion, respondent put makeup on a she knew had been inflicted on him by her son. The respondent was asked about whether she used makeup to cover up multiple occasions, and her story has changed over time. She was asked during her testimony in juvenile court in 2019. She was asked by a Fox 2 News reporter in 2019. She was asked by the Judicial Tenure Commission twice, and she addressed the issue in her answer to the complaint filed in December of 2020. Pay particular attention to how her story about using makeup to cover her son's has changed. The truth is always the same. Lies change. Respondents' changing stories show she has not been truthful about applying makeup to her grandson's
The truth is
face.
always the same. Lies change. And her story about the makeup changed repeatedly. She first said, "I didn't put makeup on any to conceal any." That is utterly preposterous. That was to a Fox 2 News reporter in 2019. But later, under oath, she admitted applying foundation to a handprint on one boy's cheek. She said it was to stop a brother from teasing him, not to conceal evidence. She claimed she told CPS about the slap and the makeup, but the CPS worker, Lacey Apple, had a different memory. She testified clearly Judge Green never mentioned any makeup. Apple's contemporaneous reports contain no such statement.
Yes. So if someone tells you something, you always put it into the investigative report? Yes. Hypothetically, if you were investigating the possibility that a child was and you interviewed a person who told you that she put makeup on a child's face that was caused by, would such a statement be important or unimportant to your investigation? Important. Why would it be important? Because it's a fact pertinent to my investigation. Would you put it into your investigative report? Yes. Can you think of any circumstance in which you would not include it in your investigative report? No. Did you do a story that aired on Fox 2 News about that case?
I did.
At some point, did you interview Judge Green about the case?
I interviewed Judge Green about some of the proceedings in the Lincoln Hall of Justice matter.
Do you know when it was that you first met with Ms. Green to interview her?
2018. It was shortly before the stories were broadcast.
All right, so we're ready to have that 6-second clip played now. Is that correct?
Yeah.
I didn't put makeup on any to conceal any. That is utterly preposterous.
So
it just didn't happen.
Mr. Elric, is that Judge Green who was speaking?
It is.
Did Tracy Green ever tell you that she put makeup on one time to cover a handprint because his brother was teasing him?
No, I have no recollection of that. If I had been told that, we would have included it in our report.
If I had been told that, we would have included it in our report, she said. That moment in the hearing room was a pattern interrupt, a stark contradiction that forced everyone to ask, who is lying? The boys themselves gave heartbreaking testimony. One said, pretty much every time we went there, I told her about the marks.
Is that
she
right?
did nothing.
Yeah. What kind of marks on your body did you show her?
My legs and arms, and my brother had face.
Did you tell her how you got those on your arms and legs?
Yeah, that my dad was doing it to us.
Did you tell her how he was doing it to you?
That he would use long stuff. If we had faces, that means he used his hand.
How many different times in your whole life did you tell your grandma Tracy about on your body and that Dad put them there?
Pretty much every time we went there.
So you said you went there a few times a month?
Yeah.
Did you tell her?
Sometimes, really occasionally, she would come over to our house, but that wasn't often.
Did you tell her about how you got the on your body a few times a month?
Yeah.
What did she do when you told her these things?
Nothing really. Like if we had to go to school or if we had to go to a place, she would put makeup on it.
Were you teasing your brother about his face?
No.
What did Grandma Tracy do when you would tell her about?
Nothing.
Did she ever ask more questions about it?
No, not really.
Did she ever call the police about it?
No.
Another recalled, she put makeup on my face. It's that simple.
Yeah, I'm telling the truth. I'm telling the truth.
Did your Grammy do anything about the fact that you had a handprint on your face?
Yeah, she put makeup on it.
Where was this, where she put the makeup on it?
In her bathroom upstairs in her house.
How did you get to her house?
Our dad drove us over there. I don't think it was just me and my dad, but I can't say for sure, but we drove over there, and that wasn't normal, normal, because I told you, we went over there regularly, so I wasn't shocked that we were at her house.
So how did it come to be that she put makeup on the handprint?
I'm pretty sure she called me upstairs. I didn't go upstairs myself, and then she called me in the bathroom, some way, some type, I don't know exactly how, but she did do that at the end of the day, and she put makeup on my face. It's that simple.
How did she put makeup on you?
She literally put on my face. Like, I came in the bathroom and she literally put on the thing was already out when I got in there, and she put on my face, and then I went home, and I don't understand why she put on my face, because it was nighttime. It was night, so I was going to sleep when I got home. It really doesn't make sense to me, but she did. And the next morning, Katie put something on my face before I got to school, and I remember I rubbed it off, and then when I got to school, everybody kept asking me what happened, and I said, I was trying, I didn't want to, because, I was trying to tell him what happened without telling him what happened. So if my dad found out that I said something, I wouldn't really get in trouble because I didn't say it. I know I didn't, but I'm telling you what she said. She said, I was telling her teasing me. I don't remember nothing about the slightest. And then she said, so she thought I was embarrassed of it, so she put makeup on it.
When they were finally removed from their father, they refused to go to their grandmother. She knew what was going on, and she'd let me go back to the person I'm afraid of, one said. Those words spoken by a child carry the weight of betrayal. And think about what they risked. They were speaking against a sitting judge, a woman who had once been their protector. They risked being called liars influenced by their mother or by CPS. Yet they kept telling the same story. Their accounts aligned with the physical evidence and the reaction of Officer Adams, who saw the boy freeze when he heard his grandmother's name. That's the kind of detail that makes a case unforgettable. Tracy Green's defense was that she only saw one slap, a pinkish handprint, and that she called her son to scold him. She argued that slapping a child is not automatically a crime in Michigan, that it falls under lawful discipline. But the JTC saw a pattern. They found she had covered up multiple incidents. They also found she lied in her legal filings, claiming she told CPS about the makeup when she had not. In her answer to the complaint, signed under penalty of perjury, she stated 5 times that she had disclosed the makeup to CPS. Then, during the hearing, she wavered.
Judge Green, did you sign a complaint dated the answer to a complaint dated December 31st of 2020?
Yes.
And did you do so under penalty of perjury?
Yes.
Is it accurate that your answer to the complaint claims that you told CPS, and I want to read an answer to you. Judge Green admits that she was aware her son had, on a single occasion, across the face. Judge Green advised Child Protective Services of this fact, and that she applied some foundation to the cheek of during a CPS interview, clearly demonstrating that she was not attempting to cover up alleged evidence or making a false statement about her knowledge. Did you answer that way, Judge?
Yes.
And did you repeat that answer or a form of that answer 4 other times in the answer to the complaint?
I believe so.
To whom at CPS did you make that statement?
If I made that statement, it would have been to Ms. Leslie Apple.
When you say if I made that statement, are you uncertain about whether you made that statement?
Well, I'm uncertain as to whether I made part of the statement.
Okay. So would you agree that you answered that same answer 5 different times in the answer to your complaint?
Yes.
A moment ago, you told us that you might have said some of it. Is that what you said?
I don't remember exactly what I said, but I think I said if I made that statement, I made it to Ms. Apple.
Why is it that you don't know if you made that statement?
Well, there are a number of reasons why. The first being that I wasn't unsure about whether I made the statement until it became very clear in these proceedings that I was being accused of not being truthful in making the statement that was in my complaint, the statements, I should say, that were in my complaint. After I realized that, I began to consider my memory about it. I began to try to recollect what exactly happened when I spoke with Ms. Apple.
When you wrote the complaint and signed it under penalty of perjury, you were certain that it was accurate, correct?
I was certain that it was accurate, but I should not have been certain.
If you said it to Ms. Apple, did you also say it to anybody else?
Well, that's just it, Ms. Weingarten. You're referring to the statement and the part that I'm having challenges with is whether I told Ms. Apple about the makeup. So I can't really say that the whole statement is something that I said if I'm not certain if part of it is what I said.
What part of it did you say?
I'm certain that I told her about the handprint, about the incident and the handprint.
Okay. Before you formed the opinion that Tracy Green was an honest person, did you know that she put makeup on one of her grandson's faces to cover an she knew was inflicted by his father?
No.
Before you formed your opinion that Tracy Green was a truthful person, did you know that she said under oath that she concealed an with makeup, but she did not tell CPS, Child Protective Services, that she did so?
No.
Before you formed your opinion that Tracy Green was an honest person, do you know that she signed a legal document called the answer to the complaint under penalty of perjury and now claims she is not sure something she wrote 5 times is true?
I'm certain that I told her about the handprint. I'm not certain whether I told her about the makeup, she said. That admission was devastating. She had signed a document under oath, and now she could not stand by it. We've all seen it in a workplace, the boss who changes their story when the pressure mounts, the colleague who remembers things selectively to save themselves. Here, that instinct was elevated to a judicial proceeding, and the erosion of credibility was total.
Happy, loving, normal.
The evidence shows that Judge Green committed 3 types of misconduct. First, she concealed that her grandsons were. Second, she made false statements about her knowledge that her grandsons were. And third, she made false statements about what she had told Child Protective Services about concealing a handprint on his face. His first statement about Judge Green that he made to Ms. Apple and Police Officer Adams is the single most important fact that has come out in this hearing. He testified he, quote, had no clue that CPS or the police would be coming to his home during the afternoon on June 24, 2018, after the police had already come and gone that morning. The boys were separated from their father, and as a result, for the first time, felt comfortable revealing the horror of what was occurring in their home. After showing Ms. Apple and Officer Adams, Ms. Apple told them that Judge Green volunteered to take them in. His body froze and he showed signs of emotional distress. He immediately said he did not want to go with his grandmother because, as Officer Adams testified, quote, she knew about what they were doing to them, and she would allow the dad to get back and come and see them, unquote. This was a spontaneous statement made without any chance of any communication with his mother. It shows that the boy's statements and the testimony about respondents' knowledge of abuse is truthful. That's the progression of Judge Green's stories about her use of makeup on the truth stays the same. Lies change. When considering credibility, please consider this. When called Judge Green in the spring of 2021, she told him she put makeup on him to prevent from teasing him. It was bad enough that Judge Green was communicating with Max, who she knew was going to be a key witness in this hearing. The facts of this case had nothing to do with his reason for calling her. Certainly, never asked, Granny, why did you put makeup on me anyhow? Rather, this only came up because Judge Green deliberately inserted her claim into the conversation. And she had no reason to do that other than to try to plant the false seed in by. In other words, she tried to do exactly the coaching that she accuses Ms. Bressler of doing. This is what judges are going to learn from this situation and this hearing. Judges will learn not to conceal from their children or grandchildren. Judges will learn not to lie under oath when asked questions about whether they knew about abuse of their children or grandchildren. And judges will learn not to lie and say they told CPS something they did not tell CPS about. Thank you.
The commission voted to permanently remove her from the bench. The case went to the Michigan Supreme Court. There, the justices wrestled with the evidence. One justice asked, "Assuming we disagree with you and find that there was misconduct, what sanction would be appropriate?" Green's attorney argued for a suspension, calling it a family matter. But the disciplinary council pushed for removal, citing a line of cases where lying under oath meant the end of a judicial career. The tension in that chamber was thick.
I think where I was sort of going with even the pre-bench conduct is when you enter the realm of under oath dishonesty, you're entering into a new realm under the case law. There are quotes that I won't get exactly right without it in front of me, but that sort of misconduct is so directly bearing upon the fitness that there, and in fact, In re Adams is one of the cases where the JTC recommended a less than removal respondent, and this court came in and rejected that for the more harsh discipline of removal because the lack of fitness tied to making false statements under oath. And I would
There's also the Simpson case, right, which is post-Adams, where there was intentional misrepresentation where the JTC requested removal and this court removed or suspended for 9 months. I mean, so I get it. It's not the easiest sort of looking at this court's history of how to fashion a sanction. But so there's evidence for, obviously, a very serious, egregious misconduct of lying under oath. So there's evidence of removal, sort of a hard line removal for that in some cases. But there is also, this court has also taken a less than a hard line removal. Why is it more akin to Adams in that line as opposed to, something, and again, I sort of focus on the lack of other evidence outside this context, this one particular incident. I say, what's the sanction for why it's closer to a hardline removal?
The false representations that were intentionally false were not under oath, and the only one that was made under oath, the court wasn't convinced was an intentional misrepresentation. So I think here what we have is the intentional under oath misrepresentation that takes you out of Simpson, puts you directly into Adams and the whole line of cases. The reason I think that the answers themselves are sufficient to find lying that deserves removal is because when the master looked at the record of the whole and the JTC deferred to those credibility findings and also on a de novo review agreed with those findings is because it found a concerted effort to unsuccessfully paint around some very careful lines. The wording, as the master found, was intentionally vague and invasive and used a mastery of language in order to only answer as close to the question being answered. And the respondent even takes, I think, some pride in that in the petition that, we did some excellent litigation drafting here. And if you wanted a better answer, you should have written a better question. But then when she gets trapped in these admissions in this investigation, she's not thinking about being investigated by the JTC at this time. When it comes to being trapped in these admissions, she's got an answer for everything. That's what the master found. That's what the JTC found. Is when I said past spankings, oh yeah, I meant before the corporal punishment order. When I said I knew that, or he meant that I didn't actually have personal knowledge of that. I learned about that through CPS and through these judicial proceedings, not that I knew about that in real time. When I saw the smack on my grandson's face that was so prominent that I, as a grandmother, put makeup on him, I didn't think that was evidence. These are all explained away, as the master put, plausible deniability. We weren't required to believe those implausible explanations, and neither the master nor the JTC did believe those.
Counsel, I want to give you another opportunity just because I don't think you had the chance to do it when you were up here before. Assuming we disagree with you and find that there was misconduct, what sanction short of removal do you feel would be appropriate?
Thank you, Justice Kavanaugh. Under the Brown factors, I think we've articulated the details of them, but we have have a single event here on a family matter. We have opposed the removal standard since the beginning when we were told what was going to be sought from this court. Justice, I think that at worst, assuming arguendo that these allegations are true, it's a family matter. She was being sincere. She was being succinct and direct in answering her questions. She didn't deceive. That would be something that would be appropriate at worst to be a censure. We respectfully request that the court reject the decision and recommendation of the commission and dismiss the amended complaint against Judge Green. Thank you.
A judge who lies under oath is not fit for the bench. That principle had been laid down in prior cases, and it was now staring everyone in the face. Then came the partial resolution. The Supreme Court found that Judge Green had committed misconduct. She knowingly covered up evidence of abuse and made false statements. But on a divided vote, they rejected permanent removal. Instead, they suspended her without pay for 6 months and publicly censured her. 2 justices would have gone further. One wrote that a judge who lies under oath is not fit for the bench and called the case for removal compelling. The majority, however, stopped short. Now, ask yourself, should a judge who concealed child abuse and then lied about it ever be allowed to return to the courtroom? That question still divides legal observers, and I suspect it will divide the comment section below. But the story doesn't end there. Tracy Green was reassigned from family court to criminal court, and recently a new case has emerged. Prosecutors appear before her now, and they've noticed a pattern. She seems to treat them with unusual hostility, as if they have something to prove all over again. As one prosecutor told an appeals panel, "I felt like I was behind the 8 ball the whole time. It was as if the burden was on the people again, like the defendant hadn't already had a trial." The appeals judges were blunt. Is there any evidence of vindictiveness? This is frankly silly nonsense that's wasting a lot of people's time. That exchange hints that the judge's past may be bleeding into her current rulings, that a resentment lingers against the very system that disciplined her. It's a troubling footnote, the kind that makes you wonder if accountability ever truly lands for those who wear the robe.
This case really boils down to 3 issues that were raised by the defendant in his successive motion for relief from judgment.
So let me ask you this, if I can just dive in. I think it's pretty clear from the record that there's some factual errors and that there's some legal errors. The case before this one was the same judge, I believe.
Oh,
so I'm curious what you think we can do as a bench to make sure that these 6500s get handled with greater fidelity to the court rules. Were the trial transcripts available? And then the second question is, what can we do as an appellate panel to kind of make sure these are being done right the first time?
I can't speak specifically as to whether Judge Green read the trial transcript. They certainly were available. I had them. Defense counsel had them. If they were requested, I certainly would have printed out a copy. But certainly,
there's a pattern. I think what we're getting at here is there's a pattern. Is there any evidence of vindictiveness or anything that he wants to bring to this court's attention that we need to be aware of? Because this is frankly silly nonsense that's wasting a lot of people's time.
Well, I certainly, as a prosecutor, felt like I was behind the 8 ball the whole time this case was going on. Like, as if the burden was, again, on the people. Like, the defendant hadn't had a trial, a direct appeal, a motion for relief from judgment where he raised 12 issues, and now we're at a successive motion for relief from judgment. I still felt like the judge was putting the onus on the prosecutor to essentially reprove the case. And I just think that in her courtroom, it seems to be that is the pattern, in my opinion. And certainly this case is an example of that.
And I didn't mean to cut you off. I just wanted to say that we've read the briefs and we've identified several legal and factual errors, but I know you were in the middle of discussing some.
Yeah, if you want to jump in on that.
She set you up so perfectly.
Yeah, I feel like
you're going to win, so what more can you say?
Right.
We're sort of at a loss as to what more we can do, because we recognize that this is unacceptable and difficult for a lot of people.
Well, yeah, I mean, not only us, not only you, not only defense counsel, but, you know, it creates a false sense of optimism in these defendants who think they're going to get another shot at the apple when clearly, you know, the law does not provide that type of relief. So it doesn't do anybody in the criminal justice system any good. And when we see, quote, repeat offenders, end quote, like this particular judge, you know, we want to know, is there something that we can do to say, hey, you know, either learn the law candidly, pay more attention, or is this vindictiveness on your part against the people?
Yeah, and I think that definitely needs exploring.
I mean, we know, we are well aware of the background here. We're aware that there was a proceeding involving this particular judge, that she was found guilty of covering up or attempting to cover up a crime committed by her son. And if there was some reverberation from that, it would not surprise me. But I don't know if that's the case. But it certainly is starting to look to be that way.
And that,
like, you're going to pay for this.
Yeah, and that's how I felt during this case, because the target kept moving. I was never, as a prosecutor, secure that these were the only issues that were going to be raised. As the case was adjourned multiple times, more and more issues were then added, changed, removed. It was a very difficult case from beginning to end. But unless the panel has any other questions, I would rest on my brief.
So what does this teach us? Judge Tracy Green was not removed. She serves on the bench today hearing criminal cases. The boys who testified suffered abuse and watched the person who covered it up keep her job. The lesson is plain: the justice system can hold individuals accountable, but it often struggles to fully police its own. When a judge breaks the law, the consequences are negotiated, not automatic. And the people who pay the price are the ones who told the truth. If you ever find yourself in a room where speaking up could cost you everything, remember those two boys who froze when they heard their grandmother's name and then spoke anyway, because they told the truth. A judge was exposed. Not removed, but exposed. And that, in a system built on public trust, matters more than most people realize. If you want to see more cases where the powerful are held accountable, or where they slip away, comment below with a courtroom interaction or case you'd like covered next. Subscribe and share this video to help build a more informed society, one story at a time.